Everybody, Joe here from Chesapeake Brokers. Just kind of wanted to briefly put something together for you guys. I seem to get this question a lot, or it always kind of pops up on the forum there, and that has to do with E&O insurance, aka professional liability insurance, aka errors and omissions insurance, et cetera, et cetera, et cetera. There's a number of different names for it. So I wanted to give you guys just kind of like a brief overview of what would be really the most time effective way for you guys to start looking at insurance, and really kind of some interesting things I think everybody should know from an insurance guy perspective. So with that being said, obvious legal disclaimer, I am not your insurance guy. I am not your attorney. I'm not providing any sort of advice in official capacity. This is for general information purposes only, and to really just kind of help steer you guys to hopefully make the best decision, right? With your own particular requirements in mind. If you ever have any questions particular to your own circumstance, please reach out to an attorney familiar with your circumstances in a jurisdiction as necessary. Okay, so let's go ahead and get started here. This is just a sample policy, and I wanted to go through and show you guys kind of some of the more interesting parts and how I would do this in the fastest time possible. Now, obviously, this is an 80-20. This is not me giving you a deep dive master's level type of course on comparing insurance policies. This is just a quick run through of one policy. Every policy is going to be different, but hopefully what I show you here will give you the tools necessary to stay out of trouble. If you get in trouble, make sure that you actually, keep that insurance and you don't get declined coverage, and as well as, really understand what it is you're dealing with here. Now, keep in mind that insurance policies are legal contracts. People don't, for whatever reason, don't seem to think of them as such. So let's go ahead and jump into this and try and figure out, what is useful here. And you're going to see kind of some interesting components to this policy. Now, a lot of people out there will go, okay, well, I have an E&O policy. Do I need a cyber policy? The answer is it depends. That's not really going to be a topic I'm discussing here. I'm not going to be talking about the structure of the policy, but I will say there's generally a large overlap between a cyber policy and a Tech E&O policy. So looking at the screen on your right, that's just kind of the policy in order. On the screen on your left are all of the definitions. And very soon it will become apparent on why exactly I do that, to really kind of run through these policies quickly. All right, screen on your right, you're going to see 3 blocks. Liability insuring clauses, you can think of that as, hey, you had a contract with somebody else, they were injured, and now, you could potentially owe them money. That's kind of what block 1 is going to be, right? You are liable to someone else. The second block there, company direct expenses insuring clauses. That is, broadly speaking, hey, you have a data breach, and these are costs that your company is going to have to pay directly absent having the insurance. Block 3, which you'll see right here, overall policy. That's just really saying the aggregate limit of liability and the premium there. Okay, continuity date, retroactive date. There is a distinction between the two. We're going to skip that for right now. What's really most important for 99% of people out there is going to be that retroactive date. Why is that important? Well, you'll see there it's a retroactive date known as inception. So that means that, hey, this policy is going to cover you from the day your policy starts moving forward until you stop paying your premium or you sell your business or shut it down. So any work you did before the inception date of this policy is technically not covered. Now, it does get a little dicey if, say, you've performed work in the past and your work in the present, and both of those time frames are covered in a claim. That's a topic for another day. That gets into really kind of some technical, deep insurance law stuff. But suffice to say, you want to have insurance because the last thing you want is, hey, you're paying for this insurance, and then a claim comes up from before you bought the insurance, and then all of a sudden you're like, oh my gosh, I didn't know what this retroactive date meant, and now everybody's angry at everybody. So make sure that you're getting that insurance as soon as possible as your business begins. Sometimes I understand there's some fiscal limitations there, but kind of keep that in mind. Next thing here, you're going to see waiting period of 8 hours right here. Now, why is that waiting period important? Well, this is for business interruption expenses. So, hey, something happens, you can't make money. That waiting period, broadly means, hey, you're going to have to wait for at least 8 hours before the policy starts responding to help you recoup. In most instances, it's going to be lost revenue. Now, you want to pay particular attention to that. Sometimes it's 8 hours, sometimes it's 10 hours. Very rarely is it under 8 hours. But if it's anything over 10, you really got to be careful. I've seen it as high as 5 days, and that can really put you in a difficult financial position, I will say. So you really kind of want to avoid something like that. And then, of course, you're going to have all these policy forms and endorsements. There's going to be a myriad of different endorsements depending upon the insurance company you're with. Sometimes this can get a little bit technical, right? That's generally kind of the last 20%, but for the most part, you can look at the main policy, and then make sure that you read those endorsements if something particularly catches your eye. All right, scrolling through here. Okay, so definitions. Why is that important? Well, this is a legal contract, and the law is really built and hinges upon how are things defined. Some of this is going to seem really kind of pedantic if you're not in this area, but it really could mean the difference between, hey, having insurance for something or not having insurance for something. So, if you go back to the top here and you look at this particular coverage section, you may just assume you have something, and you don't actually have that thing when you read the definitions. And that's why going through the definitions is really that important. I'd say actually going through the definitions is more important than reading that declarations page, because the deck page could really say anything, but it's what the policy means as it is, labeled in the language here that actually makes a difference. All right. So company, that's really, you. So you'll see here, parent company, subsidiary, additional named insured, et cetera, et cetera, et cetera. Right, moving on, you'll see all these sort of definitions. Those are all fairly standard here. You want to look at this representation section. Why is that important? It's important because what they're getting at here is, hey, you need to take the application seriously. Most policies have this representation section. And what it really means is you can't just, pencil whip an application and then assume that nothing bad is ever going to happen. If you make some sort of material misrepresentation in your policy, then, there's kind of some nuance to it, but an insurance company could try and deny coverage on that. Needless to say, obviously you never want to lie on an insurance policy, but you also really need to be as truthful as you possibly can on that application. So if, depending on how your business is set up, let's say you have offices in different states, or you've got different silos in your company, depending upon, let's say, the particular business area of those clients. Maybe you've got one for lawyers, architects and engineers. You've got one for HIPAA people. You've got one for restaurants, et cetera. You want to make sure that you're including those people as you fill out the application to make sure that you're not doing something that could come back to bite you later. Cancellation, that's really kind of, a couple parts there. Generally, that's, hey, you cancel the policy for whatever reason. These are your rights. Generally, that's expanded upon in the state mandatory endorsement. And the second part is generally if the insurance company decides to cancel on you, what are your rights there? What are their particular obligations? How soon do they have to tell you before your policy renews, et cetera, et cetera, et cetera. All right, authorization clause. All right, this is saying that, hey, you agree to act on behalf of all the insureds, and the insureds agree that the parent company will act on their behalf. Why is that important? Well, if a staff member knows about something, doesn't tell you as management, and then later you get burned, right, with a claim or potential claim that's not covered, that could be a problem. So it's not necessarily just that, the business owners need to actually understand what their obligations here are, but the staff need to know that as well. Or at the very least, the staff need to be, empowered or aware that, hey, this is what we expect to be brought to our attention, and it's for insurance purposes. So yeah, maybe you screwed something up. You made an honest mistake, or you were tired and you screwed something up. Well, we still need to know about it, because if we don't report this, then it can become a very, very expensive mistake. All right, moving through here, territory. Why is that important? Well, hey, to my Canadian brothers there, all those good folks in America's Attic. A lot of you guys seem to have clients who are down here in the States, so you just kind of want to check to make sure, hey, if we get sued in American court, for example, and we're a Canadian company, would the policy respond to that? Likewise, if you have clients that are overseas that you're dealing with, hey, if we get sued in their court, will the policy respond? Now, broadly speaking, I would say that, a lot of foreign companies, in many respects, actually tend to come to American courts because we have such a mature legal system with an absence of corruption in most regards. So, generally it's not going to be a big deal, but in the off case that it is, you want to make sure that you have the right territory under your policy. Okay, moving on here. This is, blah, 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 blah. Okay, meat and potatoes. If there is nothing else you want to know about inside of your insurance policy, the one thing you really want to narrow down is, what is professional services? Why is that important? Well, generally speaking, you're going to be covered for wrongful acts claims made against you providing professional services. You provided professional services to somebody. That person alleges that they were then somehow harmed, right, due to an error or omission. See how it's all coming together? So with that, check the definition of professional services. So if you go over here to the left-hand side of the screen, you will see professional services means any services actually or allegedly provided to a client or customer of the company, including, and you'll see here this really operative clause, but not limited to. Why is that important? Well, you want to have the broadest possible definition of professional services. So that may seem kind of counterintuitive. Like you would think, hey, I want them to lay down exactly what I'm doing, like to a T. But one, that's really difficult to do. And two, you have to be careful because, it's very easy to kind of step outside of that very structured list. So in this case, looking on the left-hand side here, you'll see this whole list of things. And I would encourage you guys, if you just want to, broadly read through that, you can pause this right now. But, generally any technology, computer, or communication-based services, firmware, hardware, software, electronic media applications, consulting, reviewing, analyzing, managing, testing, or auditing services. That's not auditing as an accountant, by the way. That would definitely be excluded. Computer and network security services, data storage, blah, 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 blah. All of those things you could be doing. So that's a very extensive list. So it includes, but is not limited to. So that's saying, hey, it's even broader than what we have on this list here. Very good thing to have inside of a policy. So this is saying, hey, we're going to cover you for professional services, your liability arising from, for a professional services wrongful act. So what is a professional services wrongful act? Well, it is right here. So it's any error or omission. So obviously E&O insurance, misleading statement, misstatement, neglect, libel, slander, or other defamatory or disparaging material, breach of duty or act allegedly committed or attempted by the insureds or by any person for whose negligent act, error or omission, or an unintentional breach of contract the insureds are legally responsible for. So once again, very, very broad. All right, technology security. So now we're saying, okay, the insurer is going to pay for you cost, charges, and expenses and damages, but you become legally liable for a technology security wrongful act. All right, so what is a technology security wrongful act? And you'll see right here, technology security wrongful act. All right, why is that important? Failure to prevent a party from unauthorized access to, use of, tampering with any company technology, including but not limited to, so once again, very broad, denial or disruption of access or services, or the functional failure of any company technology. Release, transmission, or distribution of malicious code from any company technology through to a third party. So what could that potentially mean? It could mean, hey, you have some sort of malicious code that gets auto-forwarded through your, say, RMM or RMS to your clients, and now they're going to come back and try and sue you for that. Well, it looks like you would, assume, just plain language reading here, that you would actually have coverage for that. All right, failure to prevent any party from introducing a malicious code, misappropriation of any trade secret, failure of technology products, theft of passwords or access codes by physical or electronic means. Why is physical in there? That seems kind of strange. Well, I have another YouTube video you can watch that actually talks about what is a breach actually. And in many states, a breach includes a theft of physical documents, right? Including PII, PHI, or PCI. All right, moving down, media services, generally not that important. We can actually look at that real quickly. All right, so what are media services? Moving through here means one of the following acts committed in the course of the insured: cyber and media related injury, negligence regarding the content of any media communication, inability of a third party who is authorized to do so to gain access to the media service. Most of you guys really aren't going to face any sort of media liability claims. Generally you're kind of talking about like libel, slander, defamation is generally kind of what goes into that pot. Just be careful if you're putting articles up on your website, or if you have a blog, that you're not infringing upon any copyrights, for example. Okay, Privacy Act violation and cyber information breach. So let's look at what is a privacy wrongful act, because that actually sounds quite important. So privacy wrongful act. All right, Privacy Act. All right, so this is a definition of a privacy act, which is going to come important later. So it means any federal, state, international, blah, 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 security of personal information, including but not limited to. So you've got Gramm-Leach-Bliley Act, you've got HIPAA, you've got Business Associate Agreement, you've got this right here, which is actually GDPR. Let's see, this looks like it's getting into CCPA, you've got COPPA. 1798 of the California Civil Code. That is not CCPA. CCPA is actually endorsed later on this policy. Okay, Privacy Wrongful Act. Error or omission right here. Misleading statement, misstatement, negative, blah, 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 which occurs solely in connection with a cyber information breach or violation of any privacy act by an insured. So what would that really kind of get into? Let's say a regulatory body brings a claim against you for violation of the Gramm-Leach-Bliley Act, or HHS-OCR, brings a violation against you for your services as a business associate of a covered entity under HIPAA. That's really what that's kind of getting into there. Privacy fines or penalties. Once again, getting into a lot of what we just previously talked about. PCI standard, we're going back to the right-hand side here. PCI standard violation fines and expenses. So if you're swiping credit cards, you have, say, a merchant services agreement, with a card processor, that's really what that gets into. Okay, additional covered expenses could mean something else. So let's go back over here to our definitions. Additional covered expenses means reasonable expenses the insureds incur at the insurer's request to attend a hearing, trial, or mediation in the course of defending a claim. So what does that generally get into? Travel expenses, whatever you charge as your hourly rate. So you have to leave work, so you're not making money because you have to attend a hearing, or you have to go to some mediation, or you have to go to a trial. It sounds like here that the policy is saying, hey, we're going to reimburse you reasonable expenses to do that. All right, company direct expenses insuring clauses. So this is really kind of getting into, and you'll see it on the right-hand side there, cyber, words following after that. All right, so cost of notification, crisis costs, recertification expenses. Let's go back to crisis costs real fast. So let's go back over here to the left-hand side of the screen. Crisis costs. What is a crisis cost? Means the following expenses. Blah, 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 blah. Reasonable and necessary fees and expenses, including the establishment and operation of a call center incurred by a public relations firm and the performance of a public relations service for the company arising from a crisis. What is a crisis? Right here means the publication in a daily newspaper, blah, blah, blah. So it's essentially, hey, your name's in the paper, or it's on the interweb somewhere. that you could have had some breach. Why would you even care about this? So there was an MSP who's down in Virginia. I think it was run by a former Navy guy, if my memory serves me correctly. And bam, he gets hit with ransomware. All of his clients get ransomware. It was in the news. I think I actually put that up on LinkedIn. And I mean, poor guy. Well, obviously, you're going to get bombarded by media requests. You're going to want to kind of squash as many rumors. You're going to want to have someone who's out there who's just professionally trained to make statements to the press, handle all that stuff for you. That can get quite expensive, obviously very stressful, right? It's looking like the policy would respond to something like that. Okay, let's look at recertification expenses. Now, kind of going back to my original statement, what is a recertification expense? So you may think, okay, well, I have some sort of like HIPAA certification, for example. Would this policy help pay to get recertified in whatever that particular HIPAA certification is? Or there's one sponsored by the UK government, which eludes me off the top of my head because it's almost midnight here. But let's look at what is a cyber breach recertification expense. Okay. So we look over here to the left-hand side. A cyber breach recertification means blah, 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 PCI standard. So that's really getting into, hey, you have to recertify under PCI DSS following a breach. You are probably not going to have the cost covered to say recertify under, some sort of HIPAA certification or some other third-party certification. It looks like you would be on your own to do that. Not uncommon, by the way, that's labeled that way. All right, technology breach or system failure related to business interruption expenses. So let's go over here. What is a technology breach? Okay, under company breach, blah, blah, blah. Technology breach means the failure of any company technology to prevent any party from any unauthorized access. So there you go. And this is all related to business interruptions. So it looks like, hey, you got breached and your technology failed. So business interruption is going to kick in. Now, what about a system failure? So let's see, means right over here, system failure means a computer interruption of any company technology located at premises the company owns or leases. So that stuff, it sounds like you just have on-prem. Now, if you're dealing with something that's off-prem, right? So like AWS or Azure or something, it doesn't look like that's actually contemplated under this particular portion of the policy. Technology extortion. So obviously that's, most likely that's going to get into obviously extortion expenses. That's going to be ransomware. Data restoration expenses. Let's see over here. All right, data restoration expenses means reasonable necessary costs incurred by the insured to engage an outside party to restore, recover, replicate electronic data in the custody, care, or control of the company. So that would be you. That is damaged or destroyed accidentally or as a direct result of a technology breach, provided 1, you can't do it yourself. And 2, can't do it yourself. All right, what does it not include? So it's not going to update, replace, restore, or otherwise improve what you've already got there. Any costs or expenses to research and develop electronic data. Economic or market value of electronic data, including third-party confidential business information, et cetera, et cetera. So there you go. All right, this is the definition section we were already talking about. All right, what's it also getting into here? Let's see, cost of notification means, right? You're also talking about a business associate wrongful act. And it also provides for a voluntary basis for cost of notification credit monitoring. Now, I have never ever once seen a company actually voluntarily notifies somebody. I've almost gone down that path, a very specific fact pattern there. But generally, you don't want to just voluntarily notify somebody, because now you could be incurring some sort of additional liability, right? You're saying like, hey, we don't know necessarily what went wrong, but we think something went wrong and you could be at risk here. So you're essentially kind of like putting your neck out there to potentially be sued. But, it's nice to at least have a voluntary notification provision, but very rarely would you ever actually use that. All right, we went through most of this. All right, damages. What is the definition of damages? So privacy fines or penalties, PCI standard violation fines and expenses. We kind of already went through that. But does not include matters uninsurable under the laws pursuant to which this policy is construed. So why is that important? Well, you don't just want to rely, and this is really more, I think you guys kind of get this, but it's more of a lesson for your clients actually. This kind of clause is also inside of a cyber insurance policy. And with that, just because you have coverage for some sort of, say, regulatory fine or penalty, in this case, privacy fines or penalties, as stated in the policy here, that doesn't necessarily mean that the insurance company is going to pick up on that. What does that mean? It means that every state, every jurisdiction, every territory, they have their own particular laws. And I am obviously not an attorney, although I do have a master's in cyber law. But what it's saying is, hey, in some of these states, fines and penalties brought by the state are actually against public policy to be insurable. So that state is saying, hey, these fines and penalties are actually designed to encourage people not to violate those statutes. And if they violate them, we want them to personally pay for this, right? It's supposed to be a deterrent. So if it's insurable, then we're not going to have the right deterrence that's in place under those particular statutes. Now, there's obviously varying opinions in some states. Under some statutes, obviously those fines and penalties are insurable. Quite frankly, we don't have enough case law out there yet to really even pinpoint a lot of these state laws. I mean, I can give you my best guess on that, but it's really going to depend upon, where you think those fines and penalties can come from. Now, it's obviously better to have coverage for regulatory fines and penalties, or aka privacy fines and penalties, than to not have it under your policy, but that's not something that you want to try and test. So once again, it's good to have, but I wouldn't bank on it always being there. It's going to depend, and it's going to depend on a lot of factors. Quite frankly, it depends on what the AG comes after you for. If it's state level, it's going to depend on what the, say, federal prosecutor comes after you for, what statutes he's using there. And, a lot of those, it just hasn't really been worked out yet. This is a very new area of the law. So I wouldn't really bank on having that kind of stuff. Although nice to have. Okay, so moving through here, these are all just kind of like additional definitions. Let's look at the definition of private information here. So obviously that means personal information. So that's going to be like, PII, social security numbers, payment card numbers, with some additional information. So like a PIN or a password for access. What's also important here is third-party confidential business information or any other information, whether public or non-public, in the custody, care, or control of you, the company, or any other entity at the direction and consent in writing by the company. So what is kind of, obviously hey, that's PII. You have someone's social security number, for example. B, third-party confidential business information. So just because you don't have, say, someone's social security number, that doesn't mean your clients don't have confidential business information that's included on your system. So it's nice to see that private information includes that definition. 3, they're talking about the care or control of another entity, right, in writing from you. So what would that really mean? That would be like a SaaS provider, AWS, Azure, right? Some sort of, cloud provider, third party. All right, we already talked about definition of professional services, quite broad, very nice. Moving down, these are a lot of the definitions that we already spoke about. So blah, blah, blah. Let's get into the exclusions here. So obviously you want to know what is included in your policy, but equally as important, right? You have to weigh the other side. What is actually not included in your policy? So this is saying, hey, these are things that we are just absolutely not going to cover. So right here, say, insurer shall not be liable for loss under this coverage section. Right, alleging based on arising attributable to blah, blah, blah. So pretty much like any way involving any of the following. Pollutants. Why do they put pollutants on there? Well, there are insurance policies specifically for that. The cleaning, monitoring, right, removal of pollutants. Obviously, like I said, another type of policy for that. Oh, the one thing we did miss, I'm sorry. Claim means. This is really, really very important for you to understand. So you need to understand what is the definition of a claim and why is that so bloody important? It's because you just naturally assume, if you've never been through this process before, and me working in the world of doom and gloom, I deal with this stuff literally every single day. I get a phone call from a client who's facing either a claim or a potential claim. So what is a claim? It's not just, hey, someone files a lawsuit against you. Obviously, you're going to report that. It's something really much more multifaceted than that. Okay, so a written demand against any insureds for monetary damages or non-monetary or injunctive relief. A civil proceeding against any of you. A civil administrative or regulatory proceeding, formal government investigation, arbitration or mediation proceeding against the insureds, commenced by receipt of a demand for arbitration or mediation or similar document, a written request by the company to toll or waive the statute of limitations. So obviously, or I shouldn't say obviously, but that would be known as a tolling agreement. What is a tolling agreement? A tolling agreement is you would get a letter from somebody's attorney, and essentially it says, hey, we're investigating this thing, right, which is probably going to be a claim against you. But we became aware of this. It looks like the statute of limitations is going to expire. The ability for us to bring this claim, the statute of limitations is going to expire before we can bring a legal action against you. We want you to waive or toll that expiration of the statute of limitations. Obviously, you want to talk to an attorney about that. Generally, companies are not okay with signing something like that. Okay, next, we want to talk about a potential claim. Now, what is a potential claim? You'll see right here, the insured shall, as a condition precedent to their rights to payment, blah, 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 give the insurer written notice of any company breach as soon as practicable, blah, 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 blah. This is in other parts of the policy as well. But you need to be reporting claims or potential claims. Now, going back up to what is a claim. A claim is, and it's very important that you know this, here we go, I'm back. All those things that we just went through. What is a potential claim? A potential claim is anything that could potentially bring rise to a claim. So it's anything that could potentially bring rise to any of this stuff. So what could potentially bring rise to a written demand against you for monetary damages or non-monetary or injunctive relief? It could be a whole host of factors. And, even the term MSP, it's like really a very broad umbrella term. It can mean a whole bunch of different things, but it means, anything where someone could come back and really blame you, right? That's kind of a good starting basis for what a potential claim is. So it's, hey, you made a known error. You think somebody could blame you for something. So one of your clients, for example, they got hit with ransomware. Now, maybe they haven't blamed you yet, right? They haven't made a demand for money or services against you, but nonetheless, they could bring a demand for money or service against you, in which case, hey, you need to report that to your insurance company. Okay, and now we're going to talk about notification and discovery. This all kind of ties in once again. So again, as a condition precedent to their rights, so that would be you as the company, to payment under this coverage section, give the insurer written notice of any claim as soon as practicable after an executive officer, risk manager, or general counsel of the company first becomes aware of such claim, but in no event later than 90 days after the end of the policy period, you don't really want to test that. When you become aware of a claim, generally a best practice there is, hey, immediately call your insurance guy. Anytime you're aware of something that could bring rise to a claim, so a potential claim, immediately call your insurance guy, start talking through it. So obviously, no later than 90 days after the end of the policy period. So you kind of have a grace period there. So like, hey, policy renews, you're into a new policy period, you've got 90 days to give that claim. Or B, if the claim is first made against the insureds during the discovery period, if purchased 90 days after the end of the discovery period. All right. 2, if during the policy period or discovery period, if purchased, any of the insureds, so that's anybody in your company, first becomes aware of a specific wrongful act, which we talked about before, which may reasonably give rise to a future claim. So here they're talking about that potential claim covered under this policy. And if the insureds are in the policy period or discovery period, if purchased, give written notice to the insurer as soon as practicable of. So what are they talking about here? Hey, these are the things that when you go to report a potential claim. Now, me as an insurance guy, when I talk to my clients, so they'll call me, they're like, hey, I have this potential claim. Generally I'm going through the policy with them to figure out, okay, what do we have to report? Who does this have to go to? And we kind of go through all of this, over the phone, but maybe you don't have that level of service or whatever the case may be. Or you're dealing with, say, an agent as opposed to a broker, and there's like, hey, if you have a claim or potential claim, you need to, call this number or write to this email address. These are the things you need to add into there. If you don't do that, it just makes the process even longer, and then everyone's going to get super frustrated. So just pay particular attention to what you're putting in there. And it's pretty straightforward, right? Description of the facts. Okay, what happened? Potential claimants. Who's part of this, right? Who could potentially come against you? How did you become aware of this? The identity of the insured is allegedly involved. Consequences which may result. Why is that important? Well, there has to be something that could arise of this, right? There has to be some potential damage that the insured could bring against you. And the nature of the potential monetary damage or non-monetary relief. So what would that really look like in narrative form? Hey, 2 of my techs came up to me this morning, and they said that, Jimmy's sandwich shop, they got hit with ransomware, and I'm not really sure how long they're going to be down, but it looks like, maybe it could take a couple days for them to get back up and operating. And this could be bad because they may come back and blame us for XYZ potential reasons. You don't necessarily always have to be, super, super technical when you write that up. Generally going to be talking to a claims attorney and claims counsel, who's going to flesh out a lot more of those facts for you. But you at least need to kind of hit those major points when you report this. Okay, let's talk about settlements, defense, and payment expenses. Why is this important? This may just sound like a bunch of nonsense to you guys, but a lot of people can get in trouble for this. So what is this saying here? It's the right and duty of the insurer, so that's the insurance company, not you, to defend any claim, including the right and duty to select counsel to defend any claim. Such duty shall exist even if any of the allegations are groundless, false, or fraudulent. So this is a right and duty to defend policy. There are something called indemnification policies. Generally, most companies, I think, unless you're very large and you have in-house legal counsel that are working for you full-time, generally you want to avoid those indemnification policies. You want to go with the right and duty to defend type of policies. But let's get into right here. The insured shall agree not to settle or offer any claim, incur any costs, charges, expenses, blah, 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 blah. So what else is this really getting into here? This is essentially saying, don't try to settle a claim by yourself. And why is that very important? Because, obviously you're not a claims adjuster. You're not an attorney. So think about this in terms of like, say, a car crash. Let's say you get into a minor fender bender and you jump out of the car and, you know, a third party is recording you and you jump out of that car and you go, hey, you know what? This was totally my fault. And let's not get the insurance company involved. And I will pay for this out of my own pocket. And we just don't have to worry about anything. Well, what have you done there that this policy is saying you really can't do? You cannot settle without insurer consent. You can't make voluntary payments. Um, and you cannot admit liability. In the instance of that car insurance scenario, the car crash fender bender, you just did all three things. Insurance companies say, hey, you can't do those things, all inside of that policy there. So just make sure that um, you're not stepping outside the bounds there, or that really could get you in trouble, and you could actually end up just nullifying your own policy without realizing it. Like, you're just trying to be a good business person, and you're like, hey, this was an honest mistake we made, and we're just going to go ahead and settle this and not get the insurance company involved because we don't want to pay our deductible. A lot of people think like that. They're going to go, hey, this would cost less than my deductible to fix, so I'm just going to go ahead and fix this, and my insurance company won't be the wiser. Generally we say that that's really not the best course of action for most people, and the reason why is because you really have no idea what the resultant costs could be, right? So you have no idea if, hey, you're going to fix that minor problem, and then that client's going to start digging deeper, or they're going to have their buddy who's an IT guy who's going to come in and try and look super smart and bring up all these other issues. Now, all of a sudden, you have a claim that's related to that previous issue or involves that previous issue, and you've already nullified your policy because you made voluntary payments, or you settled without insurer consent, or you admitted liability. So avoid something like that. It comes up more frequently than you would imagine. Kind of a broad best course of action is, just think about, okay, maybe I don't know how they could come back at me. So why don't we get the insurance company involved? These policies are very cheap. Let's talk to an attorney about this first before we decide to pay somebody and potentially nullify an insurance policy. Okay, next inside the policy here on the right, you're going to see various duties that you are owed to the insurance company following some type of incident. So you want to make sure that you're actually reading through these duties and you're adhering to them appropriately. A lot of these are going to be, you have to somehow prove something. So make sure you're kind of aware of what these things are before disaster strikes. So this is obviously a cyber information breach. You've got a technology threat, technology breach or system failure, technology fraud, theft, loss. Sorry, it's almost 12:30 here. These are all things that, you kind of want to know what this stuff is for and what it says your responsibilities are going to be before that event occurs, because you're going to want to have the appropriate documentation in your files as you're going through to try and fix this problem, to make sure that, if you do have to evidence some sort of loss, or there's additional material that you're going to have to provide later on to the insured, that you're not just glossing over that information, and then somehow that could come back to bite you, or an insurance company could say, oh, well, we didn't get XYZ. We can't, you can't prove to us that this loss existed because you didn't take the appropriate steps as detailed in the policy. So make sure that you're reading through all of these particular duties that you owe to the insurance company following some type of event. Okay, and with that, that's pretty much the 80-20 on how I think you guys should, start kind of thinking and contemplating about your policy. So what do we really cover here? Make sure you look at the definitions and you read through those so that you are appropriately covered. Make sure that you understand what the waiting periods are, what your particular duties are in the event of some type of loss. Make sure you understand what a claim is and what a potential claim is. I cannot emphasize that enough. Claims and potential claims, make sure you understand what those definitions are. Make sure that your staff understand what those duties are, on their regard, that they need to bring that information up to you. Even if it's an error that they caused, it's much better that you know about it, so then you can start making that determination on reporting to the insurance company, as opposed to them holding on to something And then, hey, whatever that, policy period is, or say it's, 30 days, 60 days, 90 days after the policy period, or if it's a late report of a potential claim that could get you in trouble and you could have your insurance denied. You want to avoid all that stuff. So make sure you really understand all those particular components. If you have any questions, feel free to reach out. On that note, it is now 12:30 and my wife is texting me wondering where I am. So hope you guys have a good night. If you have any questions, comments, etc., hope I can help. Stay safe.